welcome to the PUCL public meeting on judicial accountability.
Chander, Uday Singh, who is our next speaker. He is a senior advocate presently practicing in the Supreme Court. Earlier, he was a journalist working with India Today and covered many important stories, including the Assam strike, the corruption in EGS, and a number of other stories. He then came to practice in the Bombay High Court. He was also, before he started in Bombay High Court, he was practicing in the industrial courts and represented Ajay Mehta's union, and then came up to the High Court where he took up many important cases. Now he is in the Supreme Court, and some of the important cases that he dealt with, one important one which I would just like to point out is the Krishna Kumar case, which basically held that repeated promulgation of ordinances as unconstitutional. That is what the Supreme Court held. And ultimately also a number of cases, for example in the demolition case also he's been appearing before this.
So what I'm going to do is I'm going to focus on this, I think, what the Supreme Court has done in these two cases, and also it has overtones in lots of other cases and so on. But let me just give a sort of flashback. We have a Supreme Court of India which during the 1970s, the 1980s, the 1990s got itself it was lauded all over the world, and it made for itself a reputation after ADM Double which was 1975. But after that, when it came back from the wild, sort of the wilderness, and started finding its sanity again post-emergency, when the pressure of a dictatorial government was lifted off its, the jackboot sort of was lifted off the necks of the judges, the Supreme Court actually went ahead and created a reputation for itself as the strongest court in the world, and a court which spoke for the lowest and the most marginalized citizen in the nation. Just to give you a brief sort of summary, in state of Rajasthan versus the Union of India, which was one of those judgments which led to Uday. In 1977, this is soon after the emergency over. In 1977, Justice Goswami said that from being the court of the rich and powerful, the Supreme Court was becoming, quote, the last resort for the oppressed and the bewildered. That was a judge of the Supreme Court in that judgment. In 1982, Professor Upendra Bakshi, who was one of the greatest commentators on the courts of India and the Supreme Court, in his essay on taking suffering seriously, social action litigation in the Supreme Court of India, he said, quote, the Supreme Court of India is at long last becoming, after 32 years of the Republic, the Supreme Court for Indians. In 1996, Chief Justice Ahmadi, who was then the sitting Chief Justice from 94 to 97, I think he was Chief Justice of India, in a speech which is really makes great meaning for a judicial process, legitimacy and institutional viability, Ahmadi said, when derelictions of constitutional obligations and gross violations of human rights are brought to the notice of the Supreme Court, it cannot be expected to split hairs in an effort to maintain the delicate balance of power between the wings of government. It must act in a positive manner that will provide relief which is real and not illusory to the parties who exercise their fundamental right in invoking its jurisdiction. So, the Article 32, which is the article under which people can approach the Supreme Court directly in a writ jurisdiction, is itself in the fundamental rights chapter of the Constitution of India. It is probably the only instance anywhere in the world of having a fundamental right. Every citizen has a fundamental right to approach the Supreme Court of India. And it is that fundamental right which Ahmadi said must be made available to every single citizen, and the Supreme Court must act firmly for examining instances of executive overreach and so on. It is that fundamental right under Article 32 which is suddenly being turned on its head and being used now to attack the invoker, the person who invokes it. So 45 years after Justice Goswami's ringing endorsement of the last refuge for the oppressed and the bewildered, we suddenly have a situation where the Supreme Court seems to have decided that it is the mighty government which is under threat from people who invoke the jurisdiction of the Supreme Court. And suddenly the government needs protection. The government needs to be protected from people who raise questions. So if you raise questions now, the Supreme Court says, how dare you have the audacity to raise questions, to question the highest in the land. So if you question the executive and you invoke the fundamental right to move the Supreme Court, you are under a threat. You are under a constant threat today that you might be suddenly told by the Supreme Court that here is a person who should be booked and proceeded against criminally for invoking the jurisdiction of the court. So, where did this come from? It comes from saying that Zakia Jafri was misled in questioning the fact that there was a massacre, that her husband, who had spoken on telephone to the Home Minister, to the Chief Minister, to the Commissioner of Police, had come there, visited him and assured him that nothing would happen. He was then, when there was a threat to burn down the entire Gulbarga society with everybody in it, he went out to try and negotiate and placate the mob and tell the mob that look, don't do this, take my life if you want, but don't burn this Gulbarga society with all the residents in it. Gulbarga, by the way, had already been burnt once, and Ehsan Jafri and Member of Parliament had rebuilt it on the same side, refusing to move out, saying no, this was the home which was burnt and we will rebuild it on the same side and we will live here because this is our nation, this is our land. He was hacked to pieces and after that they still burned it down and they killed, I don't know, multiple numbers, tens of 68 people killed, burned alive in that thing. What was Zakia Jafri asking for? She was asking the Supreme Court to investigate whether this was part of a larger conspiracy. And the larger conspiracy, it was made very clear in the argument by Kapil Sibal that we are not arguing anything about the meeting in the Chief Minister's chamber, which was earlier, because the Supreme Court has already ruled that is not a relevant factor. So this was drummed in, argued repeatedly at every stage that is completely off the table. We are talking about a larger conspiracy in the state as a whole, with large numbers of officials deliberately not doing their duty. What was the conspiracy? Then you look the other way, you wait, you allow the mobs to free hand for 7 days, and then you start taking action to supposedly close the stable doors after everybody has been killed. Now, had this been an isolated petition, I can understand. I mean, I can't understand. But had it been an isolated petition, perhaps there would be some bizarre remote excuse to justify what the Supreme Court said with regard to the person who brought the petition. I'm not even going into the fact that they refused to entertain the petition because the Supreme Court can do that. But to say this in a case where the Supreme Court itself had found evidence of conspiracy and found that justice cannot be got in the state of Gujarat and had moved the West Bengal case out of the state of Gujarat to Maharashtra. The state Supreme Court had found that justice could not be done and moved the case of Bilkis Bano out of Gujarat to the state of Maharashtra. These cases were ultimately heard, the trials were conducted, and convictions resulted in the state of Maharashtra. Now, Bilkis Bano's case was one where I think 8 members of her family, 3 days after the Godhra riots, their homes had been burnt. They were on the streets. They were 200 kilometers away from the place where they actually belonged, because they were just trying to look for running for safety, looking for refuge. They were massacred. And these are findings of the Supreme Court. Okay, so I'm not saying anything off the cuff. They were all massacred, including a 3.5 dismiss the petitions of the appeals of the police, etc., who were convicted. 2018, for what had happened in 2002, and the Supreme Court here in Dhakia said 16 years later you are still trying to keep the pot on the boil. So the courts have found conspiracy. Now what happens after that in Bilki's file is very interesting. The SLP of the police is dismissed, so all the convictions are confirmed. Now Bilki's, she had a writ petition pending, so she said, her lawyer said, and she was supported again by, it was not Tista directly, but there were other human rights defenders. She said that I must be compensated. Look at what has happened to me. I've been orphaned, I've lost my entire family, my 3.5-year-old daughter was not only hacked to pieces, but her body was never found. So she couldn't even get fired and put to rest the body of her daughter who was hacked in her presence. And she was now 40 years old. So she said, I must be compensated. The compensation given to me by the Sessions Court of some 2,000 rupees or something is illusory. The Supreme Court in 2020 awarded her, the judgment is actually on 23rd April 2019, awarded her 50 lakh rupees. The Gujarat government was directed to pay her 50 lakh rupees to provide her a house and to provide her employment, but of course the Supreme Court asked if she is willing to accept the employment that they give her and the house that they were to provide, if she is willing to accept the house that they provide, because the Supreme Court obviously knew that they provide some house to her or something. But so this same Supreme Court finds that a 50 lakh compensation has to be given to a victim of these same riots, and 68 people who have been killed over there should not be investigated as part of that larger conspiracy which had taken so many lives. About 1,000 or 2,000 lives were taken during that 7 days of inaction. Now, what was Zakia Jafri, the widow, who had seen her husband being massacred and 68 people being killed in her presence, what was she asking for? She was just asking for an investigation. Okay, you don't want to do it, reject your petition. You want to make a mockery of yourself, do it. You have a right, as the Supreme Court of India, to say that whatever we did in 1977, whatever we did in the 1980s, the great reputation we made as the most powerful court in the world, we renounce it. We are now the executive court of the country. We will do what the executive wants. Do that. But in this matter, Issa was petitioner number 2. They refused to entertain her because Issa had made an intervention application in the Gujarat High Court that was rejected. So she came as petition number 2 in the Supreme Court. The Supreme Court rejected her intervention. The Supreme Court in its judgment starts by saying they are not hearing petition number 2 and they are not going into that aspect because they only decide Zakia's case. So having done that, having shut her out of the entire thing, they then at the end condemn her and make observations against her, a person who they themselves say they are not going to hear you. So she was only there in name. And they make these observations against her, which now in the bail order, the judge has entirely gone on that, saying this is what the Supreme Court said, therefore I can't grant bail. Now, if that wasn't bad enough, what happened with Himanshu Kumar is really, really shocking. In 2009, 19 tribals were killed in a village. Now, there was at that time the famous Operation Green Hunt. This was not a BJP government, this was a Congress government. But they had launched this Operation Green Hunt in the entire tribal areas, and it was war against their own citizens. And they had created a militia which was armed by the government called Salva Judam. So there were atrocities galore. Villages were being burned. And at least it's documented that 68 or 70 or 80 villages were burned. They followed 645. I'm sorry, I have the figure completely wrong, and I apologize for that. 644 villages were burned. When we talk about the Rohingyas in Myanmar or something, we were doing exactly the same to our citizens in the Red Corridor, what they call the Red Corridor. So, in that period, Himanshu Kumar moves this petition saying that 19 people have been killed. Among those petitioners, Himanshu Kumar, even one survivor from that massacre was a petitioner, and the relatives of each one of those 19 was a petitioner. Himanshu Kumar was only petitioner number 1. There were 19 other petitioners, relatives of each one of people killed. At some stage where a sessions judge from Delhi was asked to investigate by the Supreme Court, recorded statements, and many of them said we couldn't recognize who killed us. Himanshu Kumar was saying that the killings are the petition procedure on the basis that the killing was state-sponsored. Now the fact is that police come in various garbs, and at that time the Salwa Judum, which was a militia, which wasn't the police because they had police bodies, but they were ill-trained. The Supreme Court ultimately struck down Salwa Judum in 2011, saying that it's an absolute travesty, it's completely unconstitutional. You're giving 48 hours training to villagers and arming them and telling them to kill their fellow villagers. So this same thing now, a 2009 petition comes up in 2022 for hearing, and they say, look, you people are liars. When the Sessions Court asked you in 2010 or 2011 or something, you said you couldn't recognize the people who killed. Obviously, you can't recognize the people who killed. They come at night, they shoot violently, and it was admitted that there had been massive police firing in that village because the hundreds and hundreds of bullets and all had been fired. There was no dispute about it. The question was, did those bullets kill those 19 or not, which requires investigation. So the Supreme Court says, but all of you people are liars, you don't even know anything, you come to the court, you waste our time. So we are dismissing this petition. Right? Again, that's your right. If you don't want to entertain a petition, you dismiss. Then they say, Himanshu Kumar has come here and wasted our time for 5 lakh rupees costs. And if he doesn't pay the cost, then it will be recovered by the state government in whatever means they want. Then, not satisfied with that, they say that the state of Chhattisgarh should now investigate whether there was some deeper conspiracy, whether they should proceed against him not for perjury, but they should proceed against him for filing false evidence in the Supreme Court of India. Now, when the Supreme Court of India says proceed for filing false evidence before me, which court is going to say it wasn't false evidence? So they have straight away convicted him. But even that isn't all. What's really amazing is they actually give a direction in terms of para 67B of the application made in 2022 after the arguments were advanced, or during the arguments and applications made by the Union of India. 2009 petition, new application in 2022, which like we said was the application. Now that application said A was holden guilty of filing false charges against the government, whole petitioner guilty of filing false charges and therefore proceed for perjury. Now perjury is okay because perjury you direct under section 340 a complaint to be filed and the complaint to be tried and the person will have a full-on defense because the court will refer to perjury. Their order is completely irrelevant in a perjury proceeding because in a perjury proceeding it has to be tried afresh. The court is prima facie convinced that you lied, but it is for the trial court to decide. So the Supreme Court says, no, we are not going into prayer A. We are giving a direction in terms of prayer B. And what does prayer B say? Pass an order directing CBI, NIA, or any other central investigating agency or any other monitoring committee as this Honorable Court deems fit and proper to register an FIR and conduct an in-depth investigation to identify the individuals or organizations who have been conspiring, abetting, and facilitating the filing of petitions premised on false and fabricated evidence before this Honorable Court, as well as before the Honorable High Courts, with a motive to either deter the security agencies to act against the left-wing Naxal militia by imputing false charges on them, or to screen off the left-wing Naxal militia from being brought to justice by creating a false narrative of victimization before the Honorable Courts. This has nothing to do with Himanshu Kumar. Investigate a larger conspiracy of anybody who ever alleges that the government or ever questions any action of the government in the Red Corridor. And now Naxal is not Red Corridor because even professors of management schools, even practicing lawyers are all considered urban Naxal. All of us sitting in this room are probably within that class of urban Naxal. So, I in any crime. So like Bhima Koregaon, the Elgar Commission was is supposed to be the root, not the attack on peaceful people who were going to celebrate a 200-year-old Mahar victory. That attack and the huge injuries caused, the riots which were caused by Milind Ekhote and Eknath so and so and all, that is all forgotten. So they say the Elgar Parishad was the root. So people who were not in the Elgar Parishad, who had never been there, who had never been to Pune, were roped in and are sitting in jail. The 16 and one of them has died. So, I mean, if conspiracy can be stretched to any extent, the Delhi riots of February 2020, all the people who were victims are said to conspire to create riots so that they can be killed and their houses can be burned down. That is the conspiracy. 13,000 page charge sheet. So, and this is a direction. This is not a liberty. This is a direction of the Supreme Court. Pass and order directly. This is. I mean, it's shocking. It's absolutely a travesty because you are actually arming a government which needs no encouragement, which needs no just no. It doesn't need any liberty from anybody because if you have a right, if they have a right to investigate a crime, they will do it, and they can do it, and they must do it. But if the Supreme Court gives a direction like this, the person who is investigated has no recourse there. No court will give you bail, no court is going to acquit you, because they will say the Supreme Court has spoken. They have already said that you are doing this by creating a false narrative of victimization before the honorable courts. That's the direction of the Supreme Court of India. So now, this is what these judgments have done, and they're going to be used. They're going to be used, misused. They're going to be the sort of the new weaponization that the government wants is given to them with these judgments. But let us see if there is this completely vengeful attitude towards human rights defenders, towards people who are social activists, towards people, because it is seen in the Foreign Contribution Regulation Act, the way that is being treated. NGOs are being treated like enemies. The whole sort of atmosphere of the country is that anybody who questions, anybody who helps the downtrodden, anybody who works with tribals, anybody who works, if Sumaira takes up sand mining tomorrow, they'll say this is anti-national because we need sand to make cement. So illegal sand mining will tomorrow she will be an urban naxal who is preventing people from illegally mining sand from all the rivers and destroying the rivers of India because you are anti-national. You're not allowing progress in this country to make cement out of sand or whatever. So let's for a moment just do a reality check. Is it that we are in this utopian nation where NGOs and activists and human rights defenders are not needed because everything is absolutely hunky-dory? Just on Tuesday, 4 or 5 days ago, on the 26th of July, Parliament was informed by the government that there were 4,844 custodial deaths since 2020. In 2020-21, there were 1,940 custodial deaths. In 21-22, there were 2,544 custodial deaths. This is informed by the government to Parliament. An average in the last 2 years of 6 custodial deaths per day. 6 custodial deaths per day. And if somebody questions it, what will they be accused of? Will they be coming in this narrative of para 67B of the Supreme Court judgment in Manjukma? Will they be told that pay 10 lakh rupees cost because you have said that there are custodial deaths happening? In the state of Uday Pradesh, which is supposed to have this very disciplined, this great anti-crime movement, etc., 501 out of those 4,844, 501 in one state alone, custodial deaths in 2 years. Custodial deaths, every single custodial death is supposed to be investigated as per D.K. Basu. There's supposed to be a full-on separate investigation. 4,800, have you heard of it? Have you read it in any newspaper? Did any television channel come up with it? This is in have this sort of situation, if you have the Bilkis Bano case where in 2019 the Supreme Court has compelled or Supreme Court finds that they say to give 50 lakh rupees cost, 50 lakh rupees in reparations to somebody. You have cases where people are incarcerated and they are coming out after 10 years, 15 years with no evidence at all. Who's fighting for them? Who would fight for these poor people except the human rights defenders? We have got cases galore. The rate of conviction under the Prevention of Money Laundering Act is 0.57%. And they are filing 5,000 cases a year, 10,000 cases a year, and they've got 0.57% conviction. Who's going to defend those people? They're all behind bars because they can't get bail. The bail conditions are so stringent that they cannot get bail. So it's only the human rights defender. And when they come out to defend now tomorrow, they'll be accused of falling foul of para 67B of Himanshu Kumar. Well, that's Gayatri is right, and as she said, the Pastor Nemola. Pastor Nemola, who's the famous thing that, first they came for the Jews, and I didn't speak out because I wasn't a Jew, then they came for the trade unionists, and I didn't speak out because I wasn't a trade unionist, and then they came for the professors, and I didn't speak out because I wasn't a professor, and finally they came for me, and there was nobody left to speak for me. So, this is what we are creating, this absolutely, Kafka-esque kind of nation where right is wrong and wrong is right, and you think whatever you say. So now with these sort of judgments, the government is armed to proceed. It's a little like having an autoimmune disease. And when you have an autoimmune disorder, your body starts attacking the cell